So we are here in Hartford, the capital of Connecticut. We're about to head into the Supreme Court and provide notice for the Tanawah family for the crimes of deprivation of rights under color law, conspiracy to deprive rights, kidnapping, and other crimes is ascertainable by the evidence on the record. The state of Connecticut here has decided that they know better than the people do about how to adjudicate crimes. And as a result, their local legislation has enacted a provision of their inferior constitution that says that they will not conduct a grand jury. They've removed it completely from the practice of adjudication of crimes. That is a direct, willful defiance of the United States Constitution and the procedures of process established, codified, and agreed upon by the majority in the Constitution of the United States. Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So when the state of Connecticut says, we're not going to conduct a grand jury, then that would be a seditious, unconstitutional act. And as a result, every single person that's here in prison in the state of Connecticut is there illegally and unconstitutionally because the state has chosen to not be obedient to the will of the people. And we must get this addressed. Connecticut, you may not enact your own alternative legislation and then subject the people to it if it is in conflict with the United States Constitution. You have no authority to create your own laws that are in conflict with the Constitution of the United States. And as a result, every single thing that you're doing is criminal, is unlawful, and it must be undone. We have to address it. So we're going to provide notice to the Supreme Court here, asking them to step up, discharge the duties of their office, fulfill the promise they made to the people of the state of Connecticut, and enforce the laws of the United States of America against criminals who work for them. Thank you so much. God bless and have a great day. Hi, my name's Tanawah Downing, and we have ongoing federal litigation at the United States Supreme Court. We have some evidence here that we need to drop off for the state of Connecticut. Connecticut's not enjoined in the action at the Supreme Court. It's actually against the state of Washington, but Connecticut has got some elements that they need to get addressed. The hope here is that this will be delivered to the justices, and that they will direct the judicial officers to act in a lawful and constitutional manner, so we can avoid any further litigation.
Let me get your response.
Okay. Yeah, sir. My name is Tanawah Downing. We have federal litigation at the United States Supreme Court. This has to do with a state of Washington issue. However, there's a need to.
You said we have litigation.
Yeah, it's in the litigation team. There's a team of us. So, but I'm here providing service on behalf of the team. So,
What team?
the team that's dealing with this case at the United States Supreme Court. So the state of Connecticut is not enjoined within it. Right, it's against the state of Washington, but Connecticut can be enjoined if we don't get some issues corrected. So we have an affidavit here that needs to go to the justices, and it's fairly self-explanatory. But our hope is that the state of Connecticut the justices will direct the judicial officers within the state to act in a lawful constitutional manner, and we can avoid any further litigation.
That needs to go to the AG's office.
No, we've already served the AG. Now we need to serve the top judicial officers. So now we're here to serve the justices. So we need to get the Supreme Court to be acknowledged for the acts of deprivation.
You don't serve them directly, you serve the AG's office?
So we're providing notice to agent. That's not the Supreme Court's agent. The clerk is the Supreme Court's agent. We have to provide notice to the agent. So that's why we're here. You see.
Who are you?
My name's Tanawah Downing, I just said. And my contact information is right here on the inside. So the top page here, certificate of service, I always handwrite mine. My contact information is on the inside. Here's the affidavit signed by the local party. And again, all we're asking is that this be delivered to the justices. All the direction is right here. The affidavit is very, very clear. When a state chooses to enact its own alternative legislation, substitutes it for the provisions and guarantees of the Constitution.
We're not the right people to serve.
No, you actually are, because you can't go to the Attorney General, because the Attorney General is not part of this agency. Huh?
Are you a marshal?
No, I'm not. But
what are you?
I'm an advocate. I deal with service. I deal with the Supreme Court and cases that are going there. So
right.
Yeah. So again, all that we're doing is that the state of Connecticut has enacted its own alternative legislation and substituted it for the provisions guarantees of the Constitution. We need to get that resolved. The state of Connecticut cannot enact its own legislation and then treat people in whatever manner they see fit. It must be consistent with the Constitution. It's all very, very clear. The justices will get it. They'll understand. That affidavit is very, very simple, very clear.
Okay.
Okay? Yeah, but so we can't go to the Attorney General because the Attorney General is actually part of the executive branch. So in order to provide notice to agent.
They're who takes service for us.
Okay, well, unfortunately, we have to deliver to the agent.
Who's we?
Me, as in our group, our team. We is in.
Who is your group? Who is your team?
That is known at a different level, but we're not exposing that at this moment. So,
Got it.
so yeah.
All right.
So, okay, thank you. Now, what was your name, sir?
My name's Carl.
Carl. Okay, and are you the deputy clerk?
Chief clerk.
Chief clerk. Okay, thank you so much.
You're
Carl.
welcome.
Okay.
Yeah, you'll.
Service has been provided on behalf of the Casanova family for the crimes of deprivation of rights under the Code of Law, conspiracy to private rights, and other crimes as ascertainable by the evidence on the record. It was received by the clerk of court, so we're on to go have a discussion over at the Capitol right now. But we have served the state of Connecticut. Thank you so much. So we're here in Hartford this afternoon, the capital of Connecticut. Just moments ago, we provided service on the Supreme Court of the state of Connecticut for the crimes of deprivation of rights under the Code of Law, conspiracy to private rights, kidnapping, and other crimes as ascertainable by the evidence on the record. We did this on behalf of the Casanova family here in Connecticut. So when a state chooses to enact its own alternative legislation and then substitutes that legislation for the provisions and guarantees of the United States Constitution, that would be unconstitutional. In fact, it's an act of sedition. Sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution to procure its alteration in an other than lawful manner. There's one way to change the Constitution, and it can be found in the Constitution under Article 5, the special amending procedures, and nowhere in it does it say that a state can enact its own laws and impose its will upon the rest of the nation. Those provisions and guarantees, the Constitution as it stands, is the bedrock of the nation. It is the foundation, and it may not be changed by typical legislative practices. It can't be made a change by the state nor by Congress. No judicial act can alter, amend, or destroy it. It must be done by an authentic act of the people in accordance with the Constitution of the United States. And until that's done, those provisions and guarantees contained within it are sacredly obligatory upon all, individually and collectively. That is the foundation of our nation. That's what we believe, and that's our faith. So here in the state of Connecticut, back in 1984, they decided they didn't like the grand jury. They were going to forego it completely. And so they removed it from their constitution. So now nobody receives a grand jury. In fact, they do not have an option for it. That is a direct facial violation of the United States Constitution, because Clause 1 of Amendment 5 says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Now it's clear. You have to have an indictment by a grand jury before arresting someone and holding them over for capital or an infamous crime. Failure to do so means that you are acting contrary to the provisions and practices that's constitutionally codified for the adjudication of crimes. So when the state of Connecticut says, we're not going to do what the Constitution of the United States says we must do, and we're going to create our own law in our inferior constitution that's going to remove a requirement of the United States Constitution, that would make that act and that law unconstitutional. It would make it seditious. The Constitution can only be changed by an authentic act of the people. Until that's done, it stands as a requirement. Therefore, anybody who relies upon the inferior state statute to deprive a person of a right guaranteed by the Constitution of the United States commits a crime called deprivation of rights under color of law, Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. Now, this is a per se crime, meaning that we don't have to prove that they intended to breach their obligation. Simply by virtue of the breach, all elements of the crime have been met because their willfulness and their knowledge derives from the promise they make. When you enter into your office, you swear by oath or affirmation that you will support and defend the Constitution of the United States. Therefore, when you fail to fulfill that promise, you have already implicitly invited punishment in the form of perjury should you fail to do so. So each one of these public officials here in the state of Connecticut who are choosing to be negligent in their duties and responsibilities have become complicit in the criminal matter, because it is a crime to deprive a person of a right guaranteed by the Constitution of the United States. That's a crime of perjury, a crime of deprivation under a color of law. And as a result, we've got an awful lot of criminals here in the state of Connecticut that are leading the people. And then we wonder why we have mass incarceration. We wonder why the people are becoming criminals, because we are simply following our leaders. So right now, we provided service on the Supreme Court of the state of Connecticut. That is the top judicial officer in the state. And we've shown them that their agents are, in fact, committing crimes, felonies, multiple felonies every single day. And as a result, these particular crimes, in fact, they're so serious that when you have a deprivation of rights under color of law that occurs in conjunction with a kidnapping, then the punishment as prescribed by law is death. These are serious, serious offenses. So this is what's happening. When the state enacted its own alternative legislation that says we're not going to do what the Constitution of the United States requires us to do, that would be a seditious act. The state committed sedition to alter the Constitution in other than lawful manner. Then when they directed their agents to rely upon an inferior state statute that permits them to deprive a person of right guaranteed by the Constitution, they committed the crime of deprivation of rights under color of law. When the prosecuting attorney committed that crime, right, and then brought that charging instrument that was incorrect to the judicial officer of the state of Connecticut, that judicial officer has a duty and responsibility to ensure that the power he exercises is consistent with his authority. If he chooses to exercise power without by relying upon someone else's abuse of power, then the power he exercises is no power at all. And he's just committed the crime of the base crime as well, deprivation of rights under color of law. Plus, he has established conspiracy by and between himself and the prosecuting attorney. So once that happens, and the judge signs that order, holding the person over for the offense without having the proper charging instrument in place, and then he signs it, hands it over to an officer, and asks that officer to go out and perform an arrest. That officer also has a duty and responsibility to ensure that the power he exercises is consistent with his authority. If he chooses to exercise power based upon someone else's abuse of power, then the power he exercises is no power at all. You have no right to make an arrest unless the proper documentation is in place. And the moment that you take someone without their willingness to go, the moment you take them into custody in an unlawful confinement, that is the crime of kidnapping, and it is a federal crime because you're holding the person over, the victim over, for ransom in the form of bail. This is Title 18, subsection 1201. So now we have a situation that's happening with every single judge in the state of Connecticut, every single law enforcement officer in the state of Connecticut, every single prosecutor in the state of Connecticut. Every single one of them are involved in a conspiracy to undermine the laws of the United States. Now, whether they're doing this willfully or negligently, it doesn't matter. Because as a public official, you have no right to self-defense. You have no right to justify the crime of deprivation of rights. Your duty and responsibility was entered into prior to you coming across any person. So when you promise to do something, upon entering your office, that is a first duty to you. You must perform. And if you fail to do so, we don't have to prove that you intended to do it. We don't have to have a finding of facts. All we have to do is show that you had a duty and you failed to fulfill that duty. And as a result, according to the laws of the United States, you're no longer fit to continue in your office. You are thereby discharged. So as of this moment, after providing notice to the top judicial officer in the state, if they do not take immediate action to correct the behavior and criminal acts of their agents, then they will become complicit in the criminal conspiracy due to their negligence. Because the laws of criminal conspiracy state any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined as offense the action. We have provided you notice, Supreme Court justices. It is now your duty and responsibility to take action to correct and mitigate these criminal acts being committed against the people of the state of Connecticut. And if you fail to do so, then you will be named as defendants in the action. You will be brought to justice. I assure you that. So we're asking you right now to step up, discharge the duties of your office, fulfill the promises that you made to the people of the state of Connecticut, and enforce the laws of the United States of America that are being committed, the crimes that are being committed against the people of the state of Connecticut by your own agents, people that work for you, under your office, your authority. You are sanctioning these crimes. I hope you're proud of yourselves. Thank you so much. God bless. Have a great day.